Shall we begin?
Yeah, absolutely.
Awesome. So, first of all, on the behalf of the Student Police Society, I just would like to welcome everyone and thank you for finding time for joining us. And I would like to introduce you our speaker. This is Mr. Teodor Glison. And as well as you could have read from the description, he has a very successful career in the domain of international corporate disputes resolution. And besides, he is very successful in the role of professor, which I enjoyed personally being a student at Grenoble.
But what I thought I'd do is just kind of introduce myself, kind of explain who I am, what I've done, some things that I'm interested in, and then open it up for just a conversation. And most of these cases, when I started out, were what we call insurance subrogation cases, mostly in the context of products liability. So when a company makes a product, that product has some sort of defect, and somebody suffers an injury, very often there's a lawsuit that follows that injury. And we were representing insurance companies who were involved. For example, if you let's say you buy a product, that product burns your house down. It explodes and it burns your house down. You might have insurance, which covers your loss. And so you're taken care of. But then the insurance company gets to take the rights that you have from suffering an injury and pursue the rights to recover the money that they ultimately paid out to you as a result of your loss. And that's called insurance subrogation. So I've been, for some years now, kind of juggling two different activities. One as a practicing lawyer, one in the academic context. But in recent years, I've had the opportunity to branch out into, I think, a really dynamic area of the law, which is what I really wanted to focus on. And that is investment law, international investment law. And I don't know if you know what that is. So I thought I'd start by just basically defining what international investment law is, kind of explaining what I've done in the field, and then from that point, kind of talking about how the field is developing, why it's a dynamic field of law, and maybe why you should be interested in this field of law. So, as I said, how did I get into this field of international investment law? Well, it was 2015, I guess, so it's almost 6 years ago now, that a client came to my old law firm, Glison. And this client had, like I said, a particular problem in an Eastern European country. I won't get into too many of the details for confidentiality reasons, but I can give you some of the basic outlines of the dispute. This particular client had significant experience managing large-scale agricultural projects, farms, and had noticed that there was a lot of available and inexpensive farmland in certain Eastern European countries. And he had been successful going into these countries and setting up large farming projects and making money, making profit, and having successful business ventures. Well, he ended up going into the Republic of Moldova, and in the Republic of Moldova set up a farm, a large-scale farm. It was about 3,000 hectares. So large enough farm, not the biggest farm in the world, but by no means a small operation. And ultimately what ended up happening is after cleaning up the fields had not been used for many years. And after cleaning up the fields, getting them ready to plant seeds, and actually after planting some seeds, a local company, a local competitor saw what was going on, and all of a sudden the leases that had been granted by local mayor's offices were all revoked in one day and handed to the local competitor company, right, as I'm sure you can imagine. And after that he fought, he tried to go to court, he tried talking to the mayors, he tried to get his lands back, him and his employees, and it got violent. In fact, he was chased out of the land. There's people who showed up with guns, and they cut the brake lines on his car, and he ultimately felt that his physical safety was compromised, and he had to flee. He left the country. He went back to Colorado in the United States, and he was looking for assistance. He was looking for help. He couldn't get any progress in the local court system. It seemed that the cards, as we'll say, were stacked against him, that the court system wasn't actually impartial, and he didn't really have any local remedy to resolve this situation. In this particular case, he was able to seek international dispute resolution because there's a treaty in place from the mid 90s between the Republic of Moldova and the United States, and it's called the Bilateral Investment Treaty. And what these bilateral investment treaties do is they protect investors. So the idea is if a US investor makes an investment in Moldova or wherever the treaty partner is, and there's a dispute between the investor and the local government, the investor has a choice. They can either go to local courts and try to resolve the dispute, or they can take their dispute outside of the local legal system and go to international dispute resolution, typically through the World Bank. Now, these treaties have a long history, right? They go back to the post-World War II era. The first treaty was in 1959 between, I believe it was Germany and Pakistan. And the World Bank got involved by creating an institution, the International Center for the Settlement of Investment Disputes, which is often referred to as ICSID. And ICSID is supposed to be a neutral forum hosted by the World Bank where investors and states can resolve these disputes. Now, typically, it goes both, in theory at least, it goes both ways. So a US investor has rights against the Moldovan government if something goes wrong, like an expropriation or something like that. And vice versa, a Moldovan investor would have rights against the US government. But if you think about that, these treaties are really designed in at their core to protect investors, and investors are much more likely to come from the US than they are from the Republic of Moldova, right? So there is an element of what we call asymmetry in these relationships. They're designed to protect investors who obviously mostly come from traditionally capital exporting nations. So there's a lot of controversy about this field of law, which I'll get into momentarily. At any rate, we took this case. We're a small law firm. Usually these types of cases are handled by really big law firms who have tons of resources. But we were a small operation at the time. We were 4 lawyers. We brought in a couple extra lawyers for help, especially with linguistic issues, because of a lot of the documents in that case with the Republic of Moldova were in Romanian or Russian, right? We also had some documents in Polish. We had documents in English. So linguistically, it was a big mess. So we needed to bring in people who could help out with that. We took the case all the way to hearing. The results, without getting into details, was mitigated. We won on treaty breach. So we were able to succeed in the sense that we found that the investment was expropriated without compensation. Of course, we asked for a very large award of damages. The other side said, no, there should be no damages. And the result was somewhere in between, as is very often the case in legal proceedings. Very often in real life, when you have a lawsuit, whether it's in a commercial context, an investment context, the plaintiff or the claimant asks for everything in the moon, right? They want everything. And of course, the defendant or the respondent says, no, they should get nothing. And that's the role of a judge or an arbitrator, is to figure out what is the appropriate amount of damages. Very rarely is it actually everything that the plaintiff or claimant asks for. Sometimes it could be, but you need, of course, good evidence for that. And I won't get into all the problems on the damages claim in that case. But in the end, it was pretty successful. Small law firms, it's hard to win those types of cases. And we won on the treaty breach claim. And we're the first law firm from the state of Colorado in the United States to actually take that type of case and prevail. And I've been also completing a fair amount of research in this field of international investment law, because there's a lot of questions which surround this field of law. And what do I mean by that? Well, as I said, a lot of these treaties, bilateral investment treaties, and sometimes multilateral, what we call international investment agreements, were negotiated, I think we could say, at the height of the neoliberal era of economic thinking. A lot of this was 80s, especially in the 90s, mid-90s. Perhaps you saw a lot of these treaties come into place at the collapse of the Soviet Union, for example, when you had new republics who were looking to attract investment into their states. But it was really all over the world. It's not a phenomenon limited to one particular region of the world. Now, this system didn't really cause too much trouble at the beginning. There really weren't that many cases filed by investors. Again, these treaties, they date all the way back to the mid 20th century, but we really started seeing more and more of these treaties in the 80s and early 90s. But people started to question the system a little bit more, beginning in the late 90s and early 2000s, because you started to see an explosion of cases. And a lot of times these cases involve, there's two types which are controversial. There's one, well, it's more than two types. There's two major types, which I think we could say are controversial. One is where you have large companies from Western capital exporting states who run into trouble, run into some sort of dispute with governments in perhaps less economically developed states due to maybe regulatory changes, okay? So let me just give a complete hypothetical here. This is not based on a real case, but it's just to kind of demonstrate where the conflict can be. Let's say that you have a mining company. A mining company goes into a less developed economic state and they start an investment, they build a mine. The less developed state changes their environmental regulations, which is going to mean that the mining company is going to make less of a profit as a result. The mining company might attempt to sue the state outside of its own judicial system using a bilateral investment treaty or an international investment agreement if one is in place. And that causes a lot of controversy. Environmental advocates, for example, would say, hey, wait, shouldn't we be able to regulate the environment and do what's in the public interest instead of putting investor rights above the public interest? And so that's one type of case that's caused a lot of consternation over the years. It's a regulatory dispute. Let me give you two real examples of that. The first is about cigarettes. Some of you maybe are smokers. And if you buy a pack of cigarettes in some countries, well, a long time ago, or not even that long ago, you buy a pack of cigarettes any of the world, if you buy a pack of Marlboros, that pack of Marlboro looks relatively similar no matter where you buy it in the world. But that's changed in recent years. Now, I don't know what cigarette packs look like in Russia, but if you come here to France and you buy a pack of Marlboro, you can't really tell that it's a pack of Marlboros, right? Or Camels or whatever type of cigarette that you like. Because they've removed the trademarks, the logos from packaging. There's one standardized form of packaging, which is a black box with maybe a warning on it, smoking kills, etc., and maybe a picture, a graphic of what smoking can do to you. And this type of tobacco packaging, which is called plain packaging, and I've written an article on this, was started first in Australia. It was the Australian government, which was the first state to successfully implement this type of plain packaging or tobacco product regulation. Philip Morris, the company, the tobacco producer, sued the Australian government. They sued the Australian government saying that by putting this packaging regulation in place, you've essentially taken our property from us. You've taken our intellectual property from us. We've got valuable trademarks that we can no longer use anymore. And they sued the Australian government for 4 billion with a B, Australian dollars. So it's something like 3 billion euros, right? So it's a very significant amount of money. And you can imagine the public outcry which occurred when that happened. And then Uruguay in South America had a similar regulation, and Philip Morris sued Uruguay shortly thereafter. So there were two of these cases. And there was huge public reaction, huge public outcry, and from a public health advocate's perspective, very fortunately, Philip Morris lost both of those cases. But you can maybe see why it's so controversial. It's a collision between these treaties which protect investor rights and the right to regulate in the public interest. In this case, the right to regulate in the interest of public health. One other example, and then I'll move on, is related to Germany. You probably all remember about 10 years ago, there was the Fukushima disaster in Japan, where you had a nuclear reactor which suffered a meltdown as a result of the tsunami. And that caused a lot of fear, legitimately, around the world concerning the use of nuclear energy. And in Germany, the regulations concerning, as a result of public pressure, the regulations concerning nuclear energy changed. And they put a moratorium on the construction of nuclear power plants. I don't know all the details of the moratorium, but they could no longer build certain types of power plants as a result of a regulation change or regulatory change. Well, the problem was there were power plants which were in the process of being built at that time. And one company in particular called Vattenfall, which is a Swedish firm, had been building nuclear power plants in Germany. And they were told to stop. You can no longer build these nuclear power plants in Germany. We've got a new law. Sorry. We're not allowing you to build these nuclear facilities anymore. Okay. Problem is, a significant investment had been engaged in by these firms, right? They put billions of euros into the project, or at least hundreds of millions. And so there's a treaty in place called the Energy Charter Treaty, which is a multilateral treaty for energy, which provides for the same type of investor-state dispute resolution, as it's called. So this Swedish firm sued Germany, again, using the World Bank facilities, and they sued them for 4.7 billion with a B euros, so a really large claim. And this case has been going on for years, and it actually just settled last week. So the German government agreed to pay the Vattenfall Swedish energy firm 1.4 billion euros just last week. And a couple other energy firms were part of the settlement as well. So you can see, and it's another area where you've got public interest, which is in conflict with investor protection. And so this has become a very controversial area of international law. But there's another type of case which I think has led to even more concern from traditionally Western capital exporting countries who put the system in place in the first place. And it's somewhat hypocritical, I must be honest. And it's the fact that originally these types of treaties, bilateral investment treaties, were between a traditionally capital exporting state and an economically developing state. So the likelihood was that if there was ever a claim, it would be from an investor from the traditionally capital exporting state against the state which is in the course of economic development. That all changed in the 90s with agreements like the North American Free Trade Agreement and this agreement, the Energy Charter Treaty, which that last example about the nuclear energy situation in Germany was about. What happened with, for example, the North American Free Trade Agreement, NAFTA, which is no longer in place as of last year, was that these claims started to be brought by, for example, U.S. firms against against the Canadian government, or Canadian firms against the U.S. government, or European traditionally capital exporting countries found themselves being sued by investors from other European states, for example, under the Energy Charter Treaty. So there's a large amount of hypocrisy that has led to the ongoing reform of this area of law. Everything was fine. The system of law seemed to work really well when the traditional capital exporting countries weren't really sitting in the respondent's chair. But from the very late 90s, early 2000s, once these states started to kind of sit on the other side of these disputes and be sued for large amounts of money, whether it's Australia or Germany or the US or Canada, they kind of started to change their approach to this field of law. And what happened was in 2017, at the United Nations, at the Commission on International Trade Law, there was a big discussion about whether there should be multilateral reform of this area of law. Because right now what you have is you've got over 2,500 of these agreements, bilateral investment treaties and international investment agreements, which exist in the world. So that means there's not really a lot of harmony in how this law works. There's not always a lot of clarity in how this law works. There's just a fragmentation. You've got, again, over 2,500 different agreements, and each agreement might be a little bit different from each other agreement. And so the question arises, should we even have this system? If we should have the system, how should it function? And since 2017, at the United Nations, at the Commission on International Trade Law, there have been ongoing state-level discussions about actually reforming this area of law. And my area of research over the last couple of years has been digging into the reforms, and more particularly, how can we come up with a system of law, international law, which has a higher level of coherency between protecting investors' rights, which has a utility, which is important in certain circumstances, but with other societal concerns like regulating public health, or regulating the environment, or meeting climate change issues and things like that. And it's not an easy question to answer, but that's kind of where I'm focusing my attention on my research. Of course, when I have a case as a lawyer, I defend my client's interests. That's a different hat that you're wearing when you're a lawyer. So I kind of look at this area of law very differently depending on which hat I'm wearing. If I'm representing a client, I will analyze whatever laws are in place. It's not about what the law should be when you're representing a client. It's about what the law is. And you're trying to interpret the law and make arguments based on the law and that in a way that best reflects your client's interests, needs. When I have the other hat on, when I have my research hat on, my academic hat on, I'm looking not at how does the law affect this practical situation, but I'm thinking about what's wrong with the law, how should the law be reformed, or how should it be changed to perhaps create a more just or better international community. But I guess public health concerns have outweighed conceptions of fairness in this context. We have to always remember that states are sovereign, right? That states can, with certain limitations on this, but states can implement whatever internal regulations that they think are best for their local circumstances. One area that this actually fits into what I was talking about is there's been a lot of restrictions on all kinds of things over the last year, which were unforeseeable just 18 months ago. And there's a big concern that there's going to be a rise in investment law cases. So what happens to all these businesses who have made investments in other countries, and then their investments were stopped by COVID restrictions? Are those firms? Are those private investment companies? Are they going to be able to sue states for putting in public health regulations? There's a lot of concern about that. That's that kind of regulatory dispute. So far, we haven't seen those disputes manifest as of yet because it usually takes some time between when a regulation goes into place and when a lawsuit might arise. It might be 2 or 3 years after the fact. That's something maybe interesting to keep your eye on. I think those lawsuits will not be by the international community. They won't be too kindly received. I think a lot of people will say, hey, this is nonsense. Don't bring these types of lawsuits. But there may be some controversial lawsuits which arise in the investment context out of these types of COVID restrictions. Whether that's a travel restriction, whether that's just shutting down certain types of non-essential businesses, we'll have to wait and see, but it could be something interesting to follow over the next couple of years. One of the things that always attracted me to the practice of law was the ability for lawyers to work for themselves. It's a kind of profession where that's made relatively simple, and it's quite common that lawyers either work by themselves or maybe with a small other group of lawyers. Some lawyers work for really big law firms with 1,000 lawyers, right? But a very large amount also work kind of individually, or like I said, in small groups. And that's just the nature of the profession. So I think that's one of the reasons I did it. When you work for other lawyers, so when you got to start working for other lawyers, it's the best way to learn. But after some time, you realize that you're just making those other lawyers money for things that you could be doing on your own, right? You've got to get your own clients. That's the hard part. But once you've learned how to practice law, it's actually something that you can be much more efficient, take the cases you want, take the clients you want, do the things you want when you're working for yourself. And you can't necessarily do that when you're working in somebody else's law firm structure. So that's kind of what attracted me to starting my own business, my own law firm, was the independence and the flexibility that afforded me. So that was really attractive to me. It's hard for me to kind of give more generalist, advice or whatever out of that because of the unique nature of the particular profession that I'm in, right? I think it's a lot harder if you're going to start, I don't know. I've had a lot of clients over in the past who are, working on, I had some clients who are working on smartphone applications or something like that. It's hard to start that kind of business where you're providing some sort of product service on your own. I think it's a little bit more complicated because maybe you've got higher capital requirements to even start your activity in the first place. Whereas in my profession, just to start my business, what do I need? I need my brain, right? I need maybe some access to some research databases and a computer. That's basically it. And if I can sell myself and my knowledge and provide good services to my client, there's very little overhead for that type of activity. And so I guess that's why it was possible and relatively simple. I wouldn't say simple, probably not the right word, but administratively simple, let's say, to start my own business with another former partner now, over 10 years ago.
You know, and I just would like to go on with that. Since you told about starting the law firm, what would you advise to ones are interested in starting their own law practices?
Well, you've got to, as we say where I'm from, you've got to grind. You've got to try to really get out there and make yourself known among potential clients, but also I think other lawyers. A lot of, and now, okay, beware that what I'm going to say is relevant from my particular legal culture, which is based in the US mostly. But I've seen this also in France. A lot of times the most important relationships you can have in law are with other lawyers, because we hand cases off to each other. We give each other business, in the sense that I might have somebody come to me and they've got a legal question that maybe I don't have experience answering, or maybe I'm just not interested in. Like if somebody came to me and said, "Hey, I want to get a divorce," I would say, "Well, I'm not the right lawyer for you, but I know this lawyer over here who's a good divorce lawyer." And this is how it works. This is how a lot of times we end up building our businesses. It's not only through getting to know clients directly, maybe through professional associations or groups like this or whatever the case may be, but also through getting to know our colleagues who are also practicing law. They're not our enemies, right? They're our friends. And the more that we are able to build those types of relationships, the more well-known you are in your professional community, and the more likely it is it's going to be, financially beneficial for you in the long run as well. So I guess that would be a big tip that I'd give. And I'd also say you just got to be prepared, especially maybe the first 2 years, especially to have some times where it's not easy, where there's going to be moments where you're looking for work, and ultimately, if you keep working at it, you keep making those relationships, things do fall into place. But it's not always easy. When you're working on your own, you don't always have someone giving you the next case. You don't know necessarily how much money you're going to make in the next month or year or whatever the case is. So you have to have a certain level of risk tolerance as well. Well, my point of view on the Russian legal system is quite limited. I've had very, very limited experience with the Russian legal system. Let me put it this way. I negotiated a contract once with a party in Russia. It was a commercial contract. It was an international contract. It was actually for the custom development of a software application. My client was in the US, and they were doing business with a firm in Russia, and my client was the software developer. And so it was a international or transnational contract, and we were, on behalf of our client, very protective in the sense that we said, we don't know anything about the Russian legal system. We're not going to know anything about the Russian legal system. So let's avoid the Russian legal system to the extent possible. Okay, how do we do that? Well, what we did is, in the contract, and the law students will know that this is just a basic principle of private international law. But what we did is we make very clear the choice of law being, in this particular case, it was US law. We chose an arbitration institution for any particular dispute arising out of the contract. Now, we had another particularity with this contract in the sense that it needed to be written both in English and Russian. So we had the contract, it was one page with 2 columns. And we had on one side, we had the English version, and then on the other side, we had the Russian language version. Now, of course, we did not write the Russian language version. We put it in Google Translate, just made sure it looked like what we thought it should look like in English, but there was no way that we could verify word for word what it would say. And so what did we do? We made sure there was also a clause in the contract saying that the English language version of this contract is the official language of this contract, because both sides can speak English, but only one side can speak Russian. So in that sense, I don't have a particular viewpoint on the Russian legal system from experience, but I can say that in my professional experience, having limited contact my advice was, let's just stay away from it because it's unfamiliar to us. And that's a very common viewpoint from lawyers, isn't it, right? If we're advising our client, we're trying to reduce the risk. And the unknown in and of itself is a risk. And so that's what we did in that particular circumstance. And that would just be my anecdotal answer to that question. But in terms, more generally speaking, yeah, I mean, I think that it's just a question of, yeah, I'm always going to view the Russian legal system from the outsider's point of view, right? And I'm always going to say, you know, if you're doing business with the Russian party, you probably don't want to give them the home court advantage or the home field advantage. You're going to want to remove your case from the Russian legal system, maybe put it in neutral arbitration or something like that. And I wouldn't blame a Russian party for doing the same thing with a French party or an American party or anything like that. That's just kind of how these international negotiations go, right? That's how they go.
That's for sure. We have a lot of appreciation, but my personal point of view is that you would better to stay away from Russian courts because the law very often doesn't tell nothing to these people.
Well, and look, that's just a reality in a lot of places in the world. You can look online, and there's what we call the rule of law index. Rule of law is the idea that every country, of course, has laws, right? But different countries have different levels of law enforcement. In other words, we can say the law is X, but maybe nobody follows the law and nobody cares. That would mean that rule of law enforcement is low. And certain countries have higher levels of rule of law enforcement than others. The countries which are seen to be, you know, the most, I guess, secure in terms of rule of law are like the Nordic countries, Sweden and Denmark, et cetera, right? And then you get, you know, down the list and countries which, unfortunately, it seems to have a correlation, at least, with economic development. And so the less developed the country is economically, perhaps, and it's not always the case, but very often the rule of law enforcement in those countries is somewhat less. In Russia, you know, like I said, we could look at it, you could look it up. You can look up the rule of law index. You can see where Russia ranks next to other countries. And I would imagine just my guess would be that it would be somewhere in the middle, right, in terms of rule of law enforcement. Countries like France or the US are right next to each other on the list. They're kind of in the upper teens or 20s, right? And like I said, those Scandinavian countries, those smaller countries seem to have, and very highly economic developed countries have cultures where the rule of law is highly enforced. You know, that means that the court system is fair and impartial. Judges are not accepting bribes. That's one thing. But there's also, you know, legislation. How is legislation created? Who's making the laws? Is it a transparent process? Is it a fair process? There's also just the general enforcement of law on the street, right? Are policemen actually fairly enforcing the law? Are they asking for bribes? Is that kind of thing going on? And that stuff's happened to me in various countries in the world. So these are not problems unique to any one place. I just want to make that clear. And that's an interesting topic. That's a whole nother topic, right? Rule of law, the enforcement of law in countries.
There was a question about your experience and about some cases you can share with us in order to show the practical application of the law. I believe that this question was not very specific, but it actually has something to do with the general interest about knowing of some of the cases you have experienced. Maybe you can recall something.
Let me just talk about a couple cases. A lot of the work I've done is in arbitration. A lot of the cases I've done are in arbitration. There was a case I did a few years back where it was a fraud case. It's a fraud case. And our client had signed, he'd started a business with somebody else. I've gotten a lot of these cases where people start businesses and then the business falls apart and they want to break up. Well, what's the problem when you break up a business? The problem is you've got money, you've got assets that you've got to split up between the parties who started the business together. Kind of like what we call a business divorce. And I've done a lot of these cases over the years. I had a case a few years back, which was interesting. It actually got a lot of attention in the United States because it created new laws through jurisprudence. But the reason that was interesting is because our client wanted to leave a business he started with somebody else because he thought the other person committed fraud. He thought the other person lied to him essentially to get him to start the business, didn't bring the money that he was supposed to bring, etc. There were a lot of problems. And the problem was our client and the other party had signed a series of 8 separate contracts to start the business. And each contract had a different clause for dispute resolution. And all of them called for arbitration, going outside of the court system and using private dispute resolution. But every single arbitration clause was different. There were just minor differences between each arbitration clause. Our client said, I don't want to go to court. Excuse me, I don't want to go to arbitration. I want to go to court. Why did our client want to go to court? Well, because court is public. And he wanted this guy who he thought committed fraud to have to go in a public court proceeding so other people would know that this court proceeding was going on. And arbitration by its very nature is private. It's not public. And it can be made confidential. So our job in that case was to file a lawsuit on behalf of our client against his former business partner and do it in the public court, even though he had signed 8 contracts saying he would not use the public court system and he would use private dispute resolution. How do you do that? Well, what we did is we analyzed each contract and we said, if we look at the arbitration clause in each contract, we see that there's differences in each one. We made the argument, it's like that there wasn't enough clarity in what the parties actually agreed to concerning dispute resolution. Think of it this way. If you and I agreed to buy a car, so you have a car, I want to buy the car, and we agree that you'll sell me a car, but we don't put any specifications about the car in the contract. We don't say what make, what model, what year, what color, what engine, any of that stuff. Did we actually agree on anything? And our argument is no, we didn't. There's not enough detail in the agreement to know what we actually agreed to. There's 8 separate agreements. We made the argument that each agreement was different. Therefore, we don't even know what the parties ultimately agreed to. Therefore, we have the right to go to court. And we won at the lower level. And it was appealed to a higher level. And it was appealed. It went in front of a judge who's now on the Supreme Court of the United States. And we actually won the case on appeal too. And then it was dropped. It didn't go to the Supreme Court of the United States. Because that argument, that analogy between buying a car but without having any details of what the car actually is, was a convincing argument to the court that we shouldn't go to arbitration. We should go to the public court proceeding. And after we won that preliminary argument, that was a procedural argument. It took a year to figure out, but once we figured that out, the other party settled the case. And said, we don't want to go to court. We don't want our other clients knowing that we're accused of fraud, et cetera. So that's one example of a type of case I've worked on. That's very much decision made in each case, and culture does play a role in that as well. So, I mean, those are just some examples. I know they're very general, but I hope that helps give you an idea of the types of cases I've worked on over the years. And I know I'm over my time, so I won't go any further.